Hello everyone. So today's lesson is on natural law, the Renaissance period. In continuation of the preceding lessons, it is proposed to discuss the contribution to natural law theories during Renaissance period. The period of Renaissance in the history of development of natural law may also be called the modern classical era. General awakening among the people, coupled with new discoveries of science during the 14th and 15th centuries, shattered the foundation of established values. Renaissance period marks a general awakening and resurgence of new ideas in all the fields of knowledge. Rationalism became the creed of the age. The development in the field of commerce created new classes in the society which wanted more protection from the state. Colonization created a rivalry among the states. It gave birth to the conception of nationalism. The cumulative effect of these developments was that there was a general wave of nationalism and a demand for absolute sovereignty of the state and supremacy of the positive law, overthrowing the dominance of church. New theories supporting the sovereignty of the state were propounded by rationalist politico-legal thinkers such as Machiavelli and Jean Bodin. Both Machiavelli Prince and Jean Bodin's Law Republic propounded the theory of absolute sovereignty of the state over and above God and heralded the beginning of the supremacy of the positive law over the natural law as expounded by Christian fathers. Thereby, the theological natural law further received blows and finally eclipsed with the revival of Greek and Roman natural law philosophy. Such a new natural law thinking powerfully supported the theory of natural rights of man and states. The natural law of the classical modern era was in essence different in form and spirit from that of medieval age, which was dominated by church, priests and the holy Christian saints. After Renaissance and Reformation in the 14th and 15th centuries, natural law ceased to be associated with church or divine. While Renaissance destroyed medieval feudal order by freeing individual from its clutches, the Reformation reinterpreted the true spirit of man and his nature on the basis of Aristotelian or Caesarean philosophy, especially as propounded by Hugo Grotius, Thomas Hobbes, John Locke, Jacques Rousseau and Emmanuel Kant. In this lesson, it is proposed to discuss their contribution to natural law theory. Hugo Grotius, the Dutch scholar, statesman, philosopher, jurist and diplomat, was the child of Renaissance and Reformation. He was a staunch supporter of Renaissance and Reformation. He propounded the theory of functional natural law in his Laws of War and Peace and formulated the principles of international law which were equally applicable to all states during war and peace. He referred these principles relating to law of nations as natural law. Grotius built his legal theory on social contract. His view is that political society rests on a social contract. It is the duty of the sovereign to safeguard the citizen because the former was given power only for that purpose. The sovereign is bound by natural law. The law of nature is discoverable by man's reason. The reason is not the reason of divine, it is a self-supporting reason of the man. Grotius believed that the rules of natural law would have validity even if you should concede that there is no God or that the affairs of men are no concern to him. Accordingly, he declared that natural law would exist and be valid even if there were no God. For him, the natural law is the dictate of right reason. Thus, he departed from St. Thomas Aquinas' scholastic theory of natural law and reason, and held that natural law was not merely based on reason, but on right reason, that is, self-supporting reason of man. Indeed, the aim of Grotius was to construct a system of natural law independent of theological presuppositions, which culminated in making natural law secular and non-religious. Thus, he broke away from the scholasticism and defined natural law not just based on reason, but on right reason. Grotius asserted that man always desired to live in peaceful society. This desire for peaceful society compels him to observe certain rules of conduct by intelligent reason. That reason constitutes rudimentary principles of natural law. Thus arose the obligation to fulfill promises, the respect for others' property, the liability to repair the damage caused by one's fault, etc. The human reason and natural law are common to mankind. The rulers must also have a peaceful society. The society of rulers is the society of nations. The law of nations is originally no other than the law of nature applied to nations. In this way, Grotius conceived a system of international law. The greatest creative work done by the natural law theory was its giving birth to the international law in the 17th century. Grotius is rightly considered as the founder of the modern international law, as he deduced a number of principles which paved the way for further growth of international law. Friedman enumerates 4 legal principles as common to private law and international law. Pacta sunt servanda, agreements must be fulfilled. Rebus sic stantibus, agreements must accord with real affairs. Principle of estoppel, which says that a person cannot deny what he has impressed on others by his own conduct. This rule may help to solve controversies on legal aspects of state promises to foreign investors. The principle of unjust enrichment, which insists that none should enrich himself at others' expense without a lawful cause. The principle of abuse of rights, which expresses a social duty in the exercise of private rights. It is an elastic principle which can be stretched even to nullify a right. These principles, which are called by Grotius as natural law and modern jurists called general principles of law, will become the foundations of the international law. Thus, natural law was extensively used by Grotius and others as the foundation of a new international law to regulate the affairs and welfare of the rising nation states. Natural law and social contract theories. Theories suggesting a compact between rulers and ruled may be found in political and legal thought over the centuries. Hobbes, Locke, and Rousseau were among those who developed the theory of a social contract. Its essential features are as follows. In primeval state, individuals were born into a state of nature, which was generally anarchic. Man's natural reason and his innate need to live within society led him to create a society by contracting with others. The essence of the social contract was the surrender of some rights and powers to a sovereign in the expectation that he would safeguard individuals and protect them against oppression. The sovereign to whom powers were transferred did not necessarily consider himself as a party to a contract. The theory of natural law in the modern classical era became a theory of natural rights of man and states. Natural law was used for the emancipation of people from political tyranny. Struggles for emancipation rose in different ways in the English Revolution of 1688, the American Declaration of Independence of 1776, and the French Revolution of 1789. The governments claimed unlimited power over the people, and the people claimed democratic rights to control the government. Both relied on social contract theories. Hobbes, Locke, and Rousseau had expressed various views on the origin of the state. From a state of nature with no law, no order, no government, men have at some time passed to the state of peaceful society by a common agreement to respect one another, to live in peace and to obey a government set up by themselves to guarantee their life, liberty and property. It was such an agreement that gave rise to the organization of state. Social contract theory implies that the state is creation of the consensus of the people and the source of the political power is the will of the people. Natural law has been used to justify revolutions on the ground that the law infringed individuals' natural rights. Thomas Hobbes. Thomas Hobbes lived during the days of the Civil War in England and hence was convinced of the great importance of state authority, which he wanted to be vested in an absolute ruler. In the hands of Hobbes, natural law theory acquires a different character. Hobbes believed that self-preservation was man's key basic instinct. According to him, prior to social contract, man lived in a state of nature, in chaotic condition of constant fear. The life of man in such a state of nature was solitary, poor, nasty, brutish and short. To escape this calamity, men voluntarily entered into social contract and surrendered their rights to some mightiest authority who could protect the natural rights of man, that is, preservation of life and security of property. This led to the emergence of the institution of the ruler, which later assumed the form of the state. Preservation of human life and security of property are the only natural rights of man, which sovereign is bound to safeguard. Hobbes defined natural law as follows. The law of nature is the dictate of right reason, convergent about those things which are either to be done or to be omitted for the constant preservation of life and members as much as lives. The natural law content in Hobbes' system is his concern for natural rights of man, securing of life, property and happiness of subjects by the sovereign. However, in protecting these rights, the sovereign is not bound by legal restraint or moral inhibition on his power. Natural law in Hobbes impels subjects to surrender all their rights and vest all liberties in the sovereign for the preservation of peace, life and property of the subjects. It is in this way the natural law became a moral guide or directive to the sovereign for preservation of the natural rights of the subjects. According to Hobbes, the sovereign had absolute power to govern, and obedience was required from all as the prerequisite of justice. Law was the sovereign's command, and no law can be unjust because it is law made by the sovereign. The sovereign alone possesses the overall power to judge what needs to be done in the interests of his subjects. Thus, Hobbes used natural law theory to support absolute authority of the ruler. Hobbes enumerated the principles of natural law, but they are shorn of all power. All law is dependent upon sanction. In his famous work, The Leviathan, he says, government without sword are but words, and of no strength to secure a man at all. All real law is civil law. It is commanded and enforced by the sovereign. There is no distinction between state and society. There is no law between sovereign and subjects. All social and legal authority is concentrated in the sovereign. The church is subordinated to the state. He denied to the church the power to interpret the law of God. The sovereign of Hobbes is not instituted and legitimized by any superior sanction like that of natural law or divine right. Sovereign is merely a utilitarian creation. Hobbes gave all power to a utilitarian secular sovereign. The absolute authority of the sovereign may be justified only as long as he has the power to protect his subjects effectively. The duty of obedience to the sovereign is brought into doubt if the sovereign seeks to destroy his subjects' rights of self-preservation. Taking inspiration from Hobbes' theory, later political and legal thinkers propounded their theories of absolutism. Austin's imperative theory of law is essentially an outcome of Hobbes' doctrine of absolute sovereignty. John Locke. Locke's famous work, Two Treatises of Government, which appeared in 1776, embodies his politico-legal thought. Locke rejected in toto the Hobbesian concept of law and the absolute despotic sovereignty of the ruler. Locke's view was that state was designed to guarantee and protect natural rights of the individuals. The idea of natural rights plays an important part in the legal and political philosophy of Locke. As stated earlier, the new political theories, which emerged as a result of Renaissance, favored absolute sovereignty of the state, undermining the importance of the individual. Therefore, in order to protect the rights of individual against the absolute power of the sovereign, a new interpretation of the natural law and social contract theories became necessary. Locke had come out with a new interpretation of the social contract, rejecting Hobbes' concept of state of nature. He stated that the life in state of nature was not as miserable and brutish as depicted by Hobbes. Instead, it was reasonably good and enjoyable, except that the property was insecure. In order to ensure proper protection of property, man entered into the social contract, surrendering only a part of the rights and not all the rights as contemplated by Hobbesian theory. Thus, the natural rights of man, such as right to life, liberty, and property, remained with him, and only the right to maintain order and to enforce the law of nature was surrendered by him. The purpose of state and law was to uphold and protect the natural rights of men. So long as the state fulfills this purpose, its laws were valid and binding. But when it ceases to do so, the people have a right to revolt against the government and overthrow it. Thus, Locke emphasized on the protection of three main rights, namely right to life, liberty, and property, which were inalienable and necessary for the well-being of the individual. Locke pleaded for a constitutionally limited government. The 19th century doctrine of laissez-faire was the result of individuals' freedom in matters relating to economic activities, which found support in Locke's theory. Unlike Hobbes, who supported state authority, Locke pleaded for the individual liberty. Legal implications of Locke's doctrine of government with limited powers. The legal implications of Locke's doctrine are far-reaching. Government has no other end but preservation, and therefore, government can never have a right to destroy, enslave, or designedly to impoverish the subjects. No part of a man's property may be taken from him by a government without his consent. Laws must be based upon the concept of equality. They may not be varied so as to have one rule for the rich and poor, for the favorite at court and the countryman at plough. Where law ends, there tyranny begins. Locke insists upon the ultimate right of the community to check unbridled power and to confine a government to areas of activities agreed with the people. Popular resistance to a government may be justified only where there has been a long series of abuses and where the very lives, liberties, and estates of citizens are imperiled. The preservation of life was to be considered as one of mankind's inalienable rights. Jean-Jacques Rousseau. Rousseau, the French philosopher and jurist, enunciated the theory of natural rights resting on the contract social, wherein he concludes that state has no rational basis except the agreement and consent of the people. He gave a new interpretation to social contract and natural law to suit the new situations. He pointed out that social contract is not a historical fact as contemplated by Hobbes and Locke, but it is merely a hypothetical conception. Prior to the so-called social contract, the life was happy and there was equality among men. People united to preserve their rights of freedom and equality, and for this purpose, they surrendered their rights not to a single individual like sovereign, but to the community as a whole, which Rousseau named as general will. Therefore, state and law are the product of general will of the people and not of reason, as proclaimed by the 17th century legal philosophers. According to Rousseau, law is the expression of the general will. A law is a resolution of the whole people for the whole people, touching a matter that concerns all. The law must relate to general interest. Law represents the general will with general interest in view and never persons or actions. The enactments of the government are merely a corollary of the general will. Nobody in the state is above law, as everybody is a member of the sovereign body, which is the source of law. Laws representing the general will cannot be unjust because nobody is unjust to himself. The essence of Rousseau's theory of general will was that while the individual parts with his natural rights, in return he gets civil liberties such as freedom of speech, equality, assembly, etc. The state and the laws made by it both are subject to general will, and if the government and laws do not conform to general will, they would be discarded. Thus, it would be seen that while Locke laid emphasis on the individual, Rousseau stood for popular sovereignty. For Rousseau, state, law, sovereignty, general will, etc. are interchangeable terms. Friedman points out that the most immediate and far-reaching influence of Rousseau's doctrine was on the makers of the French Revolution, who took up his theory of popular sovereignty to justify revolution without end or measure. His doctrines of liberty and equality, added to those of law, exercised a strong influence upon the formative era of American independence and the rights of man. Rousseau glorified the collective will as the embodiment of what is good and reasonable. Emmanuel Kant, Transcendental Idealism. The close of the 18th century and the beginning of the 19th century was the watershed of the natural law philosophy. The period produced two greatest legal thinkers, Emmanuel Kant and Jeremy Bentham. While Kant was the staunch supporter of natural law theory, Bentham was the founder of analytical positivism. Kant conceived the law of nature as a principle of human reason, a kind of rational system capable of rational deductions on ethical lines. Such a pure reason cannot be derived from empirical observations or by a process of induction. According to Kant, the law of reason is purely logical category, not influenced by external factors or ends or empirical choices or experiences. Law of reason is a moral imperative directing the human being to do what is morally good for all at all times and places, irrespective of ends, considerations, or selfish desires. Kant made a distinction between hypothetical and categorical imperatives. He said that all imperatives command human will either hypothetically or categorically. Hypothetical imperatives present the practical necessity of possible action as a means to achieve something which one desires. Thus, hypothetical imperative is selfish, interest-oriented, and can never be a universal imperative. The categorical imperative would be one which presented an action as of itself objectively necessary without any particular regard. It is to be done for its own sake because it is a dictate of pure reason. It is obligatory and has to be complied with in all times and all places. Kant's test of rationality of an imperative is its universality. Accordingly, he gave the content of categorical imperative as act in such a way that maximum of your action can be made the maximum of a general action. Kant taught that insofar as man is part of the world of reality, he is subject to its laws and is to that extent unfree. But his reason and inner consciousness make him a free moral agent. The actions of man as a free agent are governed by aims, and the ethical basis of action has also to be accepted a priori. Justice, according to Kant, originates in pure practical reason. People know a priori how to act justly. Kant propounded two principles of practical reason. Act in such a way that the maximum of your action can be made the maximum of a general action. This is the famous categorical imperative. An action is right only if it can coexist with each and every man's free will according to universal law. This is the principle of right. Kant proceeded to urge that the individual should not allow himself to be made the means to an end, since he is an end in himself. Kant laid down certain principles of natural law. Human reason is law creating and constitutes moral law. Freedom in law means freedom from arbitrary subjection to another. Separation of powers is necessary to prevent the emergence of a despotic regime. Sole function of the state is to ensure the observance of law. Rules are necessary for social existence. Society unregulated by right results in violence. Social existence and violence are incompatible. Man has an obligation to enter into society and to avoid wronging others. Society has to be regulated by compulsory laws. These compulsory laws are derived by pure reason. What is needed is a rule of law, not of men. Thus, Kant's contribution is purely an ideal to serve as a standard. This lesson is a moderate attempt to cover natural law theories during the Renaissance period.